OKFM 101.7.
Mama Musa, Supreme Court ruling. Some shared the Adamanimia in the Superior Court of Judicial in the Supreme Court Accra, Ghana, AD 2022. Koram Nye, Joche, Amagacha, Zakote, Owusu, Mrs. Lovelace, Johnson, Onyenyuga, and then Kulindi. Ruling how many by at you saying?
Oh, I mean, not just that you are not monitoring me. I've been speaking since last Friday on this matter. Now, ruling no, I have to film. I have a hotel. It's the court. No, I come here said the court entered judgment without averting its mind to send your parliament a juma. You know, my criticism is the brave, but no pay no. They are making me a canon. It's answer the court no enya butre and or ye shusemu efa parliament juma die no send ye no send ye say no at the sign at the internet sa the new say anka on be master judgment. But ansana never kwame but ansana meko a hono maminka assembly. There are factual inaccuracies in the judgment.
Sir.
One. On the 26th day of November, Friday 26th of November, Ada rejected budget in our parliament. No. Then you 137 members in our parliament. Then you 274. I just have to pay. And I made Juma. According to the records, no visa permission.
Now, judgment in actual say.
Judgment in it, we were 137. And I am still struggling to appreciate which document the judges relied on to make that factual statement, which has turned out to be incorrect. You see, and the court. Copy 3 of the ruling, and start from the top.
Okay, page 3 of the ruling.
Yes.
In a challenge to the ruling of the speaker, the majority asked that the vote be retaken by decision.
Okay.
Before the revoting, the majority walked out of the chamber in protest of the exclusion of the Minister of Finance from the chamber before the vote. After a short suspension of sitting, the speaker returned to continue with the business of the House in the absence of the majority. With 137 members present, the speaker put the question for approval of the 2022 budget to voice vote.
Okay. Kwame, end it there. You see, so who are quite now kasa, a difference who court now kasa. Because someone court Nikebiano, there's a presumption of regularity about it. And the court, court, and kasa basa. Who court as someone who could be a one in a soul. And the court ought to have regard to the proceedings of Parliament for the day. Because Okase present in Parliament, what do you mean? There's only one document any people, whether you were present or not in Parliament. That is the vote and proceedings of Parliament. Kwame, read further down.
Okay. Me to also. After a short suspension of sitting, the speaker returned to continue with the business of the House in the absence of the majority. With 137 members present, the speaker put the question for approval of 2022 budget to vote. Following the voice vote, the speaker ruled that the motion had been lost and the budget rejected. On the 30th November 2021,
thank you.
When the House reconvened, the majority was in the chamber, but this time the minority was absent.
Thank you.
The speaker was absent, and consequently, the first deputy speaker was presiding. The majority leader submitted that there were only 137 members in the House when the budget was purportedly rejected, in breach of the Article 104 of the Constitution, among others. He therefore invited the first Deputy Speaker to set aside the decision of the House on the 26th November 2021 as a nullity. The first Deputy Speaker, before putting the question to the House for a decision pursuant to the motion, ascertained by the head count that there were one half of members present, as required under the Article 104(1) of the Constitution. In so doing, the first Deputy Speaker was counted as part of the half of members present to make up 138.
Okay.
He did not vote.
No.
Okay.
Yes.
Okay.
Once on the 30th of November 2021, according to our votes and proceedings, there were only 138 members in Parliament. Maybe I can WhatsApp this document to you.
Okay.
So why would the court agree and say that on 30th November, according to the votes and proceedings, there were 138 members, but we will not agree to the figure of 274 that were present in the House on 26th November. So that's the American. And it is based on this singular finding of fact, and a court they reject issue 3. And or did dismiss issue 3 in the judgment. And those are the issues. And I'm also curious why court are touching on whether or not the decision by the Speaker to ask the Finance Minister to leave Parliament was more important in the scheme of things. Why did the court not comment on that particular issue?
Maybe it was BB and a matter in contention.
It's a form part of the problem, sir. It's a bar for interpretation. So it was the duty of the court to touch on the regularity of that directive. In the Constitution, if you are not a member of Parliament, now a division has been called. It is the duty of the Speaker to ask all non-members of Parliament to leave the chamber and leave the gallery. So why didn't the court touch on the constitutionality of that directive? Because it was the basis upon which the majority walked out. But I'm happy about one thing, that the court traced the proceedings for that period. Say, a vote has been carried, and they decided to challenge. Kwame, so uko ni buasem na anyawode na launch appeal. Now you walk away from the appeal if you don't pursue it. A bit
Why?
Why? Because you have to go and prosecute your appeal.
Okay.
So
but you can't just walk away from the appeal.
Yes. So by analogy, if as a majority caucus in Parliament, Momo de Mubajet about Parliament, now you take a vote. Now also and there should be a division which is a head count. I said you are challenging the decision of the Speaker. In fact, that is the way the court puts it. They challenge the decision of the Speaker. When you challenge and you don't pursue the challenge, who should wait for you?
Oh, okay.
So if you challenge something and you don't stand to move to persuade the Speaker with your challenge so that he will make a determination, you think Parliament should wait for you?
No.
Yes. So the whole night, the process that happened, it was not truncated. And I'm happy they also said after a short suspension, we didn't adjourn. And if you go into the Constitution, if you go to the interpretation clause, the Constitution defines sitting of Parliament to include a continuous sitting without adjournment. So all these are constitutional issues with the finding of fact that the court came to.
Now, honorable, Mammy Sawadi,
let's go into the meat of the matter.
Okay.
Now, When you are a deputy, OPK or no or okay council. When you are a deputy, who says that when you are a deputy, when you are a member from Formina or Bekwai, and as a member from Southern, when I get the privilege to be nominated by a group of MPs to be elected as first speaker or first deputy speaker or second deputy speaker or even a speaker tomorrow, when I do that, it's about the deputy, so let's leave it there. To be elected as a first or second deputy speaker, if I get the opportunity, and there's an opportunity for me to preside over the house, and for the period that I preside, I am unable to vote because I'm sitting in the speaker's seat, I lose the opportunity to represent my people of Southern. Who told him that? Where are they getting some of this thinking and information from? Well, I mean, this is how, because they don't appreciate what happens.
But this is the case, sir.
No, hold on. With all due respect to him. When you are sitting in the speaker's seat, Kwame, you are giving higher powers. In fact, say, me first deputy speaker, nami kotna speaker kunyemwa. I exercise the powers of the speaker according to Article 297 of the Constitution. I exercise the speaker's powers in the seat. Entina say debate bana OPK no sorry no jina wa me pa me friend no. Na man friend na won't mean kasa. Kwame, which power is greater than this? Hello?
I don't meet you.
Number 2. For your vote now and in Parliament room.
What about the Patronsa? What about 295? No, 295.
No, 297H.
H, you know, huh? And no, and I know I'm in a Mudin Comono. Like lawyer Gary Nimakon was say, where's directing or empowering a public officer to do any act or thing, or otherwise applying to him by the designation of his office, includes his successors in office and all his deputies and all other assistants. Was the way any related to the matter in contention?
How is it not related? Is a speaker of parliament a private citizen?
Was it when you can be to Serbia? The assembly been in
Gary shouldn't even make those law school arguments. Which portion of the Constitution is not relevant?
It's not related to the matter.
Hold on. Doesn't you know that as a lawyer, when you are reading the Constitution, you read the whole document together to understand the purpose for which we make provisions?
Okay.
How do you rely on a portion of the Constitution and don't rely on a portion which is relevant to a matter?
Mm-hmm.
So tell him, sir, let me say, when you are reading a Constitution, you read it as a whole. You don't read provisions in it and leave the others. To be able to come to a purposive interpretation of the constitutional provision, you have to read the whole document. Even marginal notes. And let me take you, for the importance of marginal notes, let me take you to Article 295, implied powers.
295, yeah?
Yes.
295 plus 2 now, okay.
Yes, look at the marginal notes there.
I'll say. If I got 295, mean kind 295, nah.
No, try. Me say kind marginal notes. No, once I show be big,
295 on. 295 in Pajomboa.
I against 295. Me show be big.
In this constitution, I say interpretation.
Yes, interpretation.
Interpretation, what's it?
Yes, and that is the power of a marginal note.
Okay. Interpretation.
Okay. So read 295.
Okay.
295B. Read it.
295B.
Yes.
Okay. It should be, you know. B no say. 2B young. References to the power to there be no 2952 no. What's it? In this constitution, in any other law, a reference to a holder of an office by the term designating his office shall, unless the context otherwise required, be construed as including a reference to a person for the time being lawfully acting in or performing the functions of that office. Yes, obi abatena obi ano. Say many of them speaker dabre kura no.
And let me Kwame one say somewhere you're very important in the young children one I am person one say the judges touch on this provision. And Omu Cambro say there's a contradiction distinction.
Mm-hmm.
And I've struggled for them to point out the contradistinction. They couldn't do it. I didn't hear because there's nothing like a contradistinction in this.
With regards to 295, no?
2952.
Mm-hmm.
So, there's nothing like a contradistinction in the matter.
Okay.
Anytime the deputy speaker or any of the deputy speakers, but for Akotran speaker, that's just a speaker.
Mm-hmm.
So, which context is the Supreme Court referring to as the context may determine? Which context? It is such a straightforward arrangement.
Was it unless the context otherwise required?
Yes, which context requires that when the speaker is not there, which context says that? Where in the Constitution does it say that in the absence of the speaker, any member can go and sit? Hold on.
Okay.
It is only when the speaker is not there.
Mm-hmm.
The first deputy speaker is the one who sits.
Mm-hmm.
When he's also not there, then the second deputy speaker. When all the three of them are not there, and no Constitution is any few hono, then you know Yanya yaka ya wohono, you better transa atuaba, and not to say tuaba, I bet to abama me, it is that film of me got down there to decide. And Kwame, under that arrangement, when I go and preside, I lose my right to vote as the member for Southside.
And that is a liability.
It is not a liability. It is a duty imposed on me for sitting in that seat.
So will you see your power to put in a vote? I will represent a constituency.
You see, you lose it temporarily because you have assumed greater rule.
Oh,
The rule
okay.
is that when there's a need for a vote to be taken, I will give the order. Do you know that when I don't give the directive for a vote to be taken, the vote cannot be taken?
Okay.
The American.
Me too, pa.
And every time in Parliament, and don't let anybody, my be account as a Parliament, where there are a lot of the issues, we only debate them, we don't take a vote. That is also a big fallacy, such an erroneous thing for the Supreme Court to say. The suggestion is that there are some businesses of Parliament that are trivial. And there are some business of Parliament that are important. That presumption is so rebuttable. Every business of Parliament is important, Kwame. And Parliament takes decision on everything. When Parliament takes a decision by consensus, it doesn't mean that we haven't taken a decision. The American.
Me too.
When we take a decision by consensus, it does not mean that a decision has not been taken.
Okay.
When we take a decision by shouting, yeah, it doesn't mean we haven't taken a decision. When we take a decision by saying, all those who are in favor say aye, all those who are in favor say no, a voice vote, it doesn't mean that is not a decision.
Okay.
In fact, say even to adopt the minutes from Friday, we take a decision. The first business we do after prayers is to correct votes and proceedings for Friday.
Mm-hmm.
We will take a decision by adopting the proceedings for Friday. So it is a true reflection of what happened on Friday. And to suppose you were honor me, we should vote on it because we should not adopt it because it does not reflect what happened on Friday.
I see. Now,
yes.
My ruling no more. Now, Sawuba conclusion now, which is the 11th point now. Okay, conclusion, no, that upon a true and proper interpretation of Articles 102 and 104, Clause 1 of the 1902 Constitution, a deputy speaker and any other member of Parliament presiding over Parliament is entitled to be counted as part of one half of members' Parliament present. We are two, no, that upon a true and proper interpretation of Articles 102 and 104, Clause 1. Next, say, na yini nyina na ode 109 no ebeka ho na afi wodi wiye na je say various articles ni niema wodo a na ewo mu a bi say 295 ni 297h ni nyina no the apex court of the land did not factor in those yana.
That is my point. If they had factored it in, they wouldn't have said that when you are a first deputy speaker or a second deputy speaker and you go and sit in the speaker's seat and you preside over Parliament, you don't exercise the powers and functions of the speaker, which includes the obligation not to vote or not to participate in debate. So is the Supreme Court saying now that the two deputy speakers, when they are presiding, they can participate in a vote like the way me as a member of Southern?
What about debates? What about debating? So,
I don't know, they can participate in a debate. They say me, I'm sorry, I bet me so, and they bet me so honorable for Southern. I give you 10 minutes to make your point. So, speaker to the presiding member to allot 10 minutes to himself and make the point. You'll be speaking to debate from the high up there, from the speaker's seat. How is it not an absurdity? Kwame, and that is not the end. You see, when you go to Parliament, you don't get up to speak unless the speaker recognizes you. Are you aware? Unimza.
Annie.
Just a speaker.
Who catch the eye of the speaker?
That's right.
Opekura bet be a sintrase
and one thing I'm saying, some of these things, the Supreme Court didn't guide itself with some of these things. It is speaker and
you think what can say you should go and practicalize it, the decision.
How do we practicalize it? When you are refused to be guided, when you made directives, you made an interpretation that is leading to an absurdity. It is part of the absurdities Ami Babe pointed out.
Okay.
So it is the speaker who recognizes the member. Even the leadership, even the majority leader, when he's up, says speaker and friend now.
Wow.
Yes. And I've seen it in the 7th Parliament. Honorable Muntaka was on his feet for 15 minutes, speaker and friend, because the matter was a very controversial one. One friend. Honorable Muntaka became, he was boiling with anger. He wanted to speak and friend, 15 minutes. He had to sit down. It is speak and friend, you can't talk. That is the power when you are sitting in that seat. That's one. The number of minutes I would ever speak and I catch. And to speak amount of time now, that's a year baby. I bet you can honorable member wind up. And Supreme Court is saying the same person should also have a vote like me. When I'm talking, the person who has the power to say I should stop should have the same right to vote with me on a matter. And number 3, Kwame, only when a voice vote is taken, the eyes have it, the nose have it.
Mm-hmm.
Now, Mr. So Mempene, as I said, me fool say, when speaker said the eyes have it, me fool say, I can't lose. The end we should have a division.
To say the prayer mark in Yebino.
Thank you.
Okay.
To say, even to get up to challenge that voice vote, speaker must recognize you before and sign of it. Do you understand my point?
Mm-hmm.
Even to get up to challenge the speaker's decision, as a speaker, as a one so no can say yes or no member, what is the problem? And someone can say, I want to challenge your ruling. And to say speaker now recognize why you can't say that.
Now,
okay, now we are the speaker will say, okay, clear the gallery and do the head count. Speaker must give that directive. So we are not speaker can say you are out of order. That is the end. There will be no division.
Wow.
Yes.
Opeko me and Twaba.
Oh yeah. What me and Twaba? Or see the voice vote is carried. Finished. If you still want to challenge
the speaker has so much power, say. Ebia voice vote. I say eyes have it. What challenge here was say the why now
Thank you.
Hey,
the speaker has that power.
Then I say who is away in Quebec court.
Thank you. And I have seen it. I have seen it with my colo eyes in parliament. Okay, so who say speaker no one might who filing formal motion to come and challenge the speaker's ruling. Most in our filing when they admit it.
Hey, speaker.
Thank you. The speaker admit here. How can you move the motion to challenge his decision?
Wow.
So when you understand all these things, the Supreme Court, I know, so avert.
Shrouded in what level of absurdity?
The level of absurdity is that the directive, the interpretation they are given will lead to chaos in Parliament. Will lead to chaos because you see, when you have a deputy speaker who has been told by Supreme Court that because you are a member of the choir, so go and exercise your voting rights, as well as now your debating rights in the speaker's seat room. When there's a controversial matter like 11, when they lay the report and they open the debate, Obetumi decided that only the majority members will debate. Do you know that he can do that?
Hey!
There's nothing you can do. Who sorry our own flow? Majority sorry our best flow. In fact, he can decide that for this debate, we are taking only one contributor. But you can decide that.
But after that, you can vent your spleen.
Sorry?
After that, you can vent your spleen.
Oh, you can vent your spleen. You can throw tantrums. You can shout. Who shout to pray? Marshal said, Marshal should discipline you. He has power of discipline. So Marshal should march you out of the chamber.
Wow.
In fact, that speaker, that deputy speaker who is presiding and can actually ask the Marshal, every minority member who want to demonstrate some form of opposition to what is happening, you will ask the Marshal to take them out, one after the other, until all the 137 are taken out.
Mami Musau, Supreme Court akasa. Na say yes, a binding on you. We no say mo anfa nyadwuma to practicalize the whole idea Supreme Court ruling na be ya. And can you be cited for contempt?
Contempt before which court? Have you read the judgment? The court itself says that however, the practicalization of these rights, all right, it lies with Parliament of Ghana. We must make regulations to give effect to practicalize these rights.
Next woman, yeah, and no, just back to square one.
Thank you. Also, Parliament, Semra, normal to give effect, say, direction, Wamano. It should be, how do you say it? We should give effect to that direction, Mama. Do you know Parliament can take 20 years to do this? Check in the judgment. They didn't give any timeline. Check.
It is as it stands now. Say more kwatuaba. Na deputy speaker tewa. Oba tubi and on tubi.
Because Supreme Court says we should make regulations to give effect to their judgment.
That's a regulation be back on answer.
Thank you. We should make regulations to give effect to that judgment. And yes, sir.
So
that regulations, the judgment cannot be given effect to.
But yeah, teacher, him say ya can wear we and yes, a bus when we are full, when we are full up.
You even have to court judgment, you have to enter it, your friendly entry of judgment, and to have it served on the judgment debtor after some days before you can execute the judgment. But this one is a constitutional matter. So it's a declaratory judgment, or your declaration. But in making the declaration, they have tied themselves. The court tie its own hands. Say they are leaving the steps to be taken to give effect to their judgment in the hands of Parliament. Who is presiding in Parliament? Is it not the Speaker?
The Speaker.
Who directs a committee that goes?
And the Speaker is not watching and I'm going to say, I didn't know.
Maybe so. Who will give the directives there? A committee, an ad hoc committee, or the standing orders committee should go and meet and come up with regulations to give effect to this Supreme Court ruling.
A Speaker.
Who do that? Is it not the Speaker?
Is the Speaker, yeah.
Oh, Kwame. This was a journey to nowhere.
Oh, a journey to nowhere. Mama say, one more comparative analysis. A ruling no a go to baby to say Canada, go to baby to say Kenya, Botswana.
You see, the common law is a beautiful jurisdiction. Common law. You can see common law. A uniform legal system. All the English-speaking countries.
I shall say probably 1066.
That's right.
Yeah.
So like half of the world practice what we call the common law.
Sure.
The other meaning is that there's a uniformity in the legal system.
Mm-hmm.
When you come to constitutional democracy, there's no two constitutions are the same. No two constitutions are the same. So you cannot go and compare what the Kenyan constitution says. When the Kenyan constitution is not analogous to the Ghanaian constitution, you cannot be comparing their system to what pertains in Ghana.
Mm.
When you go and compare the constitution from Canada, Canada hasn't got a constitution. Canada it's a British. Canada is not a republic.
Mm-hmm. Just like Australia.
Yes, they are not republics. So if you go and take the Canadian scenario, it is not applicable to Ghana. If you go and take the US practices a federal system. They have a bicameral legislature. They have a double chamber. They have a lower house and an upper house.
But
the Ghanaian legislature is a unicameral legislature. We have only one house.
Mm-hmm.
So you can only be comparing what is prevailing in another national assembly when their constitution makes prescriptions similar to what we have.
But with an inference to their speakers respectively, as we have here, say, they vote.
When the constitution says that this is what should be done, you can't go and say that in Nigeria, which is a federal state, this is what their constitution says.
Okay.
You can't go to Kenya and say that in the Kenyan constitution, which is not similar to our constitution, this is what it says.
Mm-hmm.
We are not Kenya in terms of constitutional democracy. We are not. We are not. Kenya, the salary of Kenya MPs is much higher than the salary of Ghanaian MPs. So where the constitutions make prescriptions, express prescriptions for things to be done in a particular way, it is the duty of the Supreme Court to ensure that they give the purposive interpretation for that prescription to be given effect to. You don't enlarge it, you don't turn it upside down, and then the Supreme Court is saying that they are adopting the literalist approach to interpretation in the Republic of Ghana. What has happened to the modern purposive approach Supreme Court has been espousing on us from about 2004 since the decision in Asari versus the Attorney General.
Okay. Honorable.
They told us that they are moved away from the literalist approach to the textualist approach. Now, the Supreme Court uses what they call the modern purposive approach to interpretation in our jurisdiction. And under that, there are two approaches: the objective purposive approach or the subjective purposive approach. Asa, and to kind Professor Azar article be or Troya. Or see the return of the literalist approach after 18.
But said the spirit and the letter of the Constitution.
Yes, as for the spirit and the letter, it doesn't vary. So if you read the judgment of this court, it doesn't lend support to the spirit and letter of our constitutional governance structure and architecture in our parliament. It does not. In fact, Kwame, let me also add, in our parliament, we have the committee system, and I heard the majority leader can say, any Supreme Court, this new Supreme Court decision in India, it will apply to our proceedings in committee level. What here? Hello?
Mete.
What here? Okay, now let me tell you what is happening at the AC committee level. Speaker of Parliament, on your member of Parliament too, but or a chairman of two committees, or a chairman of the Standing Orders Committee, are Yeditro Emra, Yedi of Parliament, be a member, speaker, and a dan. So Rebecca says speaker, on your member of Parliament, he won't chair this committee.
You chair.
And you know that as chairman of the committee, he has a casting vote. And do you know that the two deputy speakers are also members of the Standing Orders Committee? They have original vote, but they don't have a casting vote because they are mere members. Okay. Two, the speaker is also a member of the Committee of Selection. Committee of Selection, and he said, for me committees now. Members are your constitutional legal and a standing orders and a public account. Committee identity two sir committees your friend is committee of selection, speaker and a dan. And also a chairman.
A baby obey me at Waba.
If he has a casting vote under our committee system, the chairman has a casting vote.
Okay.
So that is the absurdity of the Supreme Court decision. That the speaker has a casting vote as chairman of two committees in Parliament, even though he's not a member of Parliament. So when they are saying that when you are a member of Parliament, you cannot be denied your right to vote. What about somebody who is not a member of Parliament but is being given voting rights at the committee level? Okay, let's go to the first deputy speaker. First deputy speaker is also the chairman of two committees. He's the chairman of the appointments committee. And he's also the chairman of I'll recall.
Okay.
I'll recall quickly. And to also appointments committee, say all the ministerial appointments vetting, on a time. Okay.
Yeah, Mekai.
Exactly. So at that committee, he hasn't got an original vote. So at that committee, when he's chairman, is he not a member for Bekwai?
A member. You're still a member of the
Bekwai. But he hasn't got original vote. He has two about on to be.
Okay.
He only votes when there's a tie. So does it mean that when he's presiding as chairman and a decision has to be taken at the committee level, he doesn't represent the people of Bekwai because he doesn't have original vote?
Now, are you honorable Bwamhekakra?
Yeah.
One more cause two case be in the case of Konyehia versus Archer, 1993-1994, Ghana Law Report 525. Well, see, this court held that a constitutional instrument is a document, signaries, whatever. Yes. To be interpreted according to principles suitable to peculiar character and not necessarily according to the ordinary rules and presumptions of statutory interpretation.
Interpretation.
I have no presumptions no ewo hene and ordinary rules no so hene any say no na a hinge on.
You see that the court even didn't go according to this dictum, this holding by the court.
I tell me go to hano.
So this decision was in, I think, 1995.
1993 to 94.
Thank you. So 1994, 93 decision. So yeah, 93, 94, and I think it was decided in 93.
Okay, yes,
almost 30 years ago.
Mm-hmm.
The Supreme Court didn't go according to the terms of this holding of the court. And let me show you why. The court proceeded in this case without taking any presumption of regularity of parliamentary procedure into consideration. So they would have analyzed the structure of decision making and committee proceedings first of all, and see how things are done there. Then they'll come to plenary and analyze the parliamentary procedures in parliament and see where, you see, all these things is about the base of power. Where does power lie in parliament? Who exercises power in parliament? Because you see, the framers for almost a constitution in mind. Almost person who are power me obetimi discipline obetimi akase me PF chamber no obetimi akase mami nkasa obetimi akase me kasa o mami 5 minutes. The framers are of the view that obia or exercises those powers no shouldn't have the same voting rights as me when he is sitting in the seat. But they have gone to twist the argument and say, obviously, we were saying that he hasn't got voting rights as if he's not a member of parliament. That is not the argument. The argument is that between when you leave your seat as an ordinary member of parliament and you go and preside in the absence of the speaker, that period, you cannot be voting on an issue that you have control over, you direct. Let me give you one critical example. Okay, sir, yeah, for me, bipartisan committee, and inquiring into the Sputnik V allegations, no?
Yeah.
Okay.
Yep.
Okay, sir, the report by Parliament.
I report by.
Okay, sir, debate. I mean, okay, sir, debate.
Yes.
Hello.
Me pato minim we debate, yeah.
Thank you. A day ni see ye debate ni we ya. Ye be put the question no. The second deputy speaker no on now Honorable Etiama. Or see he has suspended the question.
OKFM.
He deferred the question. He deferred the question from about July last year until this year. That question was never put. Fami, umbisa
Adentia.
Adana ye debate no na NDC for near thought to MPP for Parliament.
Mm-hmm.
All right?
Yeah, me too.
And and this came from a speaker who at that time known himself as Yakunyama on debate on to about.
Mm-hmm.
But they did it. Also that he was deferring the question. So we didn't vote. He didn't give us the opportunity to vote. Minority, that was all that we could do. Because the speaker has spoken. It wasn't a Siama who spoke. It was the speaker. It was the speaker who said he was deferring the question to another time. It took over 7 months for that to be done. So, if a speaker has such enormous powers, and you think that if that day Siama had done the calculations and And going by Supreme Court interpretation, if he had done the calculation and discovered that the numbers are such that if he asks his vote, it will tilt it. So a chairman will put the question, then a voice vote will be carried. So all those in favor say aye. Then the minority, they report they can say aye.
I think okay, ni we are. Me no say wo sori kwa aka say there be a vote counter. And no opa baka say there be.
Me say Kwame, no opa on mount kasampo because he knows what you want to do.
Okay.
It is an answer to mount kasana see mo pesi a year head count crowd because you are out of order. No abangi gavu no asa.
Hey.
Where you?
Okay.
But the point I make is say it is oputi question, you know. Let's imagine, say, and let's maintain say, that they no oputi question. Konya thought is on by about 50 members.
Mm-hmm.
And the oputi question, as all those in favor of adoption of the report say aye. Now, yeah, minority, yeah, CM aye. Now, majority side are almost person morning to know. All those, not those in favor say no. No, Mark say no. Now, Supreme Court say, a chairman soon can say no. Or can no, Nivea. No, I can see the news have it.
Okay.
Kwame.
101.
Hey, simple cry.
And see, these are the absurdities.
Oh, okay.
Yeah.
Honorable, medal se pa se waje brena oso ni edi nkomo bibia ni a.
Mama infa we nka ho.
Okay.
And Kwame Bebre bisa say are we interested in a review? We are weighing the options. Say whether we go for a review on very patent legal grounds, on grounds of error of law contained in the
But say whereby you are now we petitioner no. Can you go for a review in that regard?
Oh, it's a constitutional law matter. In fact, what I said, I mean from the beginning, I advise that we should have joined as an interested party. But what is curious, Kwame, and it's there are two other cases. The Abdullah there we come one. I had 3 cases, and you're filing on this issue. One was filed by Richard Sky. The other was filed by lawyer. They'll see. Apia Kubi.
Andy Apia
Kubi.
Yeah.
He also filed one. And see, my humble question to the court is, why didn't they consolidate these 3 cases?
Etika omo amalgamate both petition na.
The practice of the court is that so the case is back court, not they are similar, not the release are similar. They consolidate. Consolidation is almost coming in our boom. No media ceremony. Because you don't want to waste the court's precious time. So maybe say, what is the fate of those 2 other cases, which were also filed also in November, sometime early December, because the controversy erupted on 30th November. So these cases were filed early December. What has happened to those cases? What is their fate? That's my point.
Na die ehawo sa baby a to ye eno no se bia mo ko reviewer mo bebu say why it wasn't taken into consideration. That is 295B no and 297H no.
Yes, we will say that if you read those constitutional provisions, if the court had averted its mind holistically to those constitutional provisions, they would have come to a different determination of the issue. And even the narration of the facts, there are factual inaccuracies. So I may point it out now. So we'll bring all those exhibits. We'll bring the hands out to show. So we were for the record of Parliament, there were 274 MPs and not 137 present for the day.
Okay.
For the day.
Any interesting days ahead. Yes, Shadi. Medicine of paper, bra.
You come to
Why, there's all upon one night, a share a hon.
Aye.
That's bra, bye.
But
Okay. Honorable Rockson Nelson, Eche Dafeamakpor, a MP for South Die, member Constitutional Legal Affairs Committee of Parliament, the United Kingdom. Pacho.
OKFM 101.7.